going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you're having a great day. Hope you're having a great weekend. All right, we got a premiere. I don't usually do premieres anymore, so I kind of wanted to schedule one. So let's go. I've got some defendants with some horrible attitudes. One from Judge Washington, one from Judge Goggins, and then I finish with, well, just you'll see. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Okay, who's handling the arraignment from the PD's office? Like, she here? Yes, she is. All right, the court will call the case of the state of Michigan versus Portia Elledge, case number 23FB1101 and 20W003404.
APA
Good
Rachel
morning,
McDuffie.
Your Honor. I'm sorry.
Okay, Ms. Chanel. APA Rachel McDuffie for the people.
Good morning, Your Honor.
The township. Sorry.
My apologies. Assistant Public Defender Sonia Chanel on behalf of Ms. Portia Elledge. Can you please have them unmute you, ma'am, and state your name for the record?
Is Portia Elledge.
Thank you. All right, Ms. Portia Elledge is here because of a bond violation. Ms. Portia Elledge is alleged to have cut her strap off and left it at the Speedway gas station at 3000 Carpenter Road in Ypsilanti Township here in Washtenaw County. And the tether was located, but not the defendant. So she's been missing since then.
That and some new cases, Your Honor.
Oh, wow. Look at that.
Oh, wow. Look at that. This is what you don't do when you're on tether. Don't cut it off. You are not going to be a big fan or judges will not be a big fan of yours. I don't know this from experience, but I do know it from watching court.
All right. Ms. Chanel.
Thank you, Judge. We are requesting an adjournment in this matter due to the new charges with my client. We will also ask for a low cash bond at this time.
Well, I can answer the first one very clearly. No. As far as the adjournment, why would we be adjourning a tether? She cut a tether off. Are there charges arising out of the tether off?
There are no, I'm sorry, Ms. Chanel, I didn't mean to talk over you if you were going.
No, go ahead, Ms. McDuffie.
I don't know about any charges related to the tether at this time. They usually move pretty quickly, so I don't anticipate she's going to have that specific charge. However, Ms. Elledge is up for a sentencing. And
I don't want to be adjourned.
Ma'am, I don't care that you want it to be adjourned. You don't get to
I
choose.
said I don't want to be.
Oh, okay. Good. Go ahead, Ms. McDuffie.
all right. So Ms. Elledge is up for sentencing on her cocaine possession felony that was reduced to use as a misdemeanor. Since that time, she has a new case authorized, which is operating with the presence of a controlled substance, second offense, also cocaine. That is from December, but it was back from a period of time when she was on bench warrant status for these cases. So it would still be a bond violation there. She also has just from this past weekend, so just from Saturday. Currently, it's authorized as an assault and battery and a retail fraud second from Macy's, but I believe there are some additional charges, likely felony weapons charges coming from that report as well. It just wasn't able to be done in time for that particular arraignment. Ms. Elledge was ordered to report for 4 times monthly testing upon her release on this case the last time, and obviously she cut that home confinement tether off immediately. I think that is the record for how fast I've seen a tether cut off within hours of her release from custody. And so that's all I know about at this time. in terms of new charges and new offenses and things like that.
All right, ladies and gentlemen, you heard it. She is a record holder. Congratulations. Fastest ever to remove the tether from her leg. You know, she can brag about that in jail.
So we have today the bond violation, and she needs to still get interviewed for sentencing. Is that correct?
That's correct, because when we saw her, they had a request for an emergency bond hearing because she wanted to get out of custody after the plea. So she was released right after that. We hadn't even gotten that far for assessments and interviews and things.
All right, bond violation and sentencing will occur on July 1st, 2024.
July 1st.
Ma'am, you need to stop speaking out during the middle of court. Do you understand? Do you understand?
Oh, the Judge Washington stare incoming. You don't want this stare, especially if you're in jail. Bad idea. And then look at Miss McDuffie. She's like, don't do it. Don't do it.
Miss Ellich, do you hear me talking to you, ma'am? Just so you know, you can get another contempt. Any contempt proceeding will be consecutive, means stacked on top of what you have right now. Do you understand that?
Miss Elledge, can you hear the judge speaking?
No, I don't hear her.
She's speaking.
She hears me.
What did she say?
Stop talking and interrupting her.
Miss Ellich, I'm not going to play games with you. We already did this once. I told you very clearly that I already had someone who cut a tether off. You said you would not do that, and you did it in record time. July 1st, 2024 at 10 a.m. Bond is denied.
Thank you, Judge.
I'm going to adjourn the other matter over to that time as well.
No, deal with the situations now.
Miss Elledge, please.
We're gonna keep adjourning for.
Nope, you can't keep talking out of context.
I'm done here.
Okay, bye.
All right. That's it for today. No, it's not.
Oh man, that pesky mute button. The most hated button to all court watchers is that mute button. They muted her right at the end, so we didn't hear her talking when she was throwing her hands up and down. All right. That was Judge Washington dealing with attitude. Now we're going to go watch how Judge Goggins handles it. Now, Judge Goggins might be the nicest judge I've ever watched. So it takes a lot to upset him. Let's go.
Let's see, Hunters Ridge versus Adamia Bradford. Nobody responded. I do have personal service on. Oh,
There we
Ms.
go.
Bradford?
Yes, sir.
Okay, Ms. Ms. Bradford, do you wish to speak with legal services?
No, sir.
No? Okay, Mr. Haldy?
All right. Ms. Simpson, the tenant Bradford owes
You're saying
$996.33 in rent. You've incurred $169 in costs for a total to redeem possession of $1,165.33.
Yes.
And you're seeking a judgment of possession only with a writ to issue after May 31st, 2024.
Yes.
Ms. Bradford, anything you want to tell me?
Yes, that is from back in January. I came to court and I did an SCR, and they said it was dismissed. It was denied. I was not made aware of being denied. I did not get made aware it was denied until I got court papers that it was denied. And then the other part of it is late fees that was accumulated before January. I thought that we had till the 10th to make payments on the rent, and that's why I didn't think it was any late fees. So that extra part, all that's from January to back earlier in the year, is not accumulated recently. And I had called Kelly this morning and told her I started a new job. I'm at work now, actually. And I work 10 to 6 at Happy Elephant Day because I started yesterday. And I told her, yes, I can make an arrangement. She said, no, just come to court. I can make an arrangement to the extra $100 each month because I don't have $1,000 to pay up front.
I can't do that.
But that's from January rent. It's not even current. If you would have gave me a notice sooner than now, then I could have made an arrangement previous to this, and it would have never got this high. You just made me aware of this just the other day. Then they give it to
Ma'am, you get a 7-day notice every month. I'm not here to argue. The figures are what they are.
There was never any notice put on the door that they were stating that those late fees
It's mailed.
Never.
It's
It
mailed.
was never. They were not mailed. Kelly, they were not.
I'm
mailed.
not arguing with her, Your Honor.
No, it's not about arguing, Your Honor. I'm telling you the truth. Why would I lie? You see, there's nobody on this line but me from this apartment complex.
So, Ms. Bradford,
I'm on this line.
hold on, Ms. Bradford. Let me just kind of ask a couple questions then. You said you're complaining about January. Were you paid in full in January?
No, I did an SCR in January and it was denied. I just got the notice recently that it was denied.
Okay,
from the office. That's how I knew. From you, from Sunridge. I mean, Huntersville, I'm sorry.
Hold on. So it wasn't paid in full in January, so there was outstanding in January. What about February? Did you get everything caught up in February?
Everything has been paid on time. February, March, April, and May has been paid on time. Those are all from January and beyond, from the past, not from current.
I understand maybe the current rent was paid, but was there an outstanding balance then from January? Is that what you're telling me?
Yes. Okay, they said the 637 was from January, and then whatever other fees are from 2023. There was never anything put on the door or no notice ever given that there was a late fee due of $25 or $15 or whatever they are. We went in the office and talked to the lady. The lady said that Kelly handles all of that. Kelly never ever made a statement on the door that said your rent and you owe $25 or $15, whatever the late fee is. There was never a note put on the door stating that I owed those late fees those months.
I don't put late fee notices on the door.
Your Honor, I put my right hand up to God and put my hand on the Bible in front of the judge and let you know there was never any else put on the door, Your Honor.
Okay, ma'am, Ms. Bradford,
right now.
Here's what I'm not understanding though. If you knew it wasn't paid in full for January, you knew there was an issue.
We did not find that out till we just found out when we had to come to court now that this is from January's rent. It's not current rent.
But how did
we went in the office and talked to the lady? I'm sorry.
I'm just confused because how did you not know there was a balance owing if what you're telling me, you said, oh, it wasn't paid in full in January, but I paid.
That's not what I said, Your Honor.
Okay, what did you say?
What I said was we did an SCR in January.
Yep, and you got denied.
When we came back to court, they said dismissed. When we came back to court, they said it was dismissed. So when they said dismissed, we were assuming that it was paid. So then.
Well, wait. Hold on. What do you mean it was dismissed in January?
All right, real quick. I don't really understand how this works with SER. If anyone in Michigan knows more than I do, please leave a comment, or this is a premiere, so you can tell me in the side chat. But if she was paying February, March, April's rent on time, why wouldn't that go back? So when you paid February, even if SER was taking your case and then denying it later, when you paid February, wouldn't that actually go towards January's rent? So I can understand why she's frustrated. She's accumulated late fees based on January's rent, even though she's paid February, March, April on time. And I don't know if they say May. I don't remember. So I understand her frustration. She needs to calm down and stop yelling, though. This is, landlord-tenant case. So there's no reason to yell. But also, whoever's this Kelly person, she's also not really doing a great job of, de-escalating the situation. She's kind of antagonizing it, kind of laughing at her and everything.
January then.
I mean, it was denied. I'm sorry. It was denied. I'm sorry. It was denied. I
Okay,
was
so
not
if
made aware it
if
was
it was,
denied.
hold on. So if it was denied, how do you come up with thinking it was taken care of?
Because, okay, you know, when I came to court the first time, you told me to do it. I did an SCI. I told you the SCI. You said, go to the court. I went to the court out in Flushing. I did the paper that stated that I had filled out for SCR. I did that paper out there.
Yeah.
And then when I came back to court the following time, it said it was dismissed. So when they said it was dismissed, when I came back the second time in January, I was assuming that it was paid. So then come around
Hold
March,
on, right there. Wait, right there. How did you assume something was paid if you didn't have any documentation?
because it was dismissed when I came back. I figured that the word dismissed mean it was paid. It was taken care of. I'm not an attorney, Your Honor. I don't know those terms. This is my first time.
I guess, Mr. Hawley, maybe you can straighten things
Well,
out.
Your Honor, I think what
I can do it right here. What she's thinking is she didn't pay January's rent. She has made payments, but the rent always goes towards the arrearage.
Yeah, but that's not making sense. If she's paid, February, I'm just repeating myself. It doesn't make sense. How is she paying late fees from January if she's been paying the previous months? That doesn't make sense. And also, he didn't address you, Miss Kelly. He addressed Mr. Haldy, not you. So, yeah, I'm not a big fan of this attorney. Also, I want to clear something up. I am not siding with the defendant, the tenant in this case. I am not at all. But all I'm saying is I understand why she's frustrated, but she clearly wasn't really paying attention to what was going on.
So February's rent went to January's rent. March's rent went to February's rent. April's rent went to March's rent.
And
The
again,
rent
I
she
know
paid
it's
in
I don't
May
know those
went
things.
to
That's something
April's
that should be
rent.
explained.
Ms.
So
Bradford,
she
what?
still
Ultimately,
owes
from
it.
January's rent, from the denial of the thing. But I'm stating is there was never when the notice came, when I went off to pay the rent, I asked the lady. When I went in to pay the rent in this is May. When I went to pay the rent in March, there was a man at the desk. The man said he don't know anything about. They just took the rent. He said the next time you talk to the other lady. When the up came again another lady, there was a lady in there. The lady stated that this is from the rent from January, which was denied, and this is what accumulated these late fees from 2023. So those late fees in 23. And as I stated, if I was made aware of those late fees during that time, I would have been paying on it.
At
And
the
so we
end
get to
of
$1,000+
December 2023, your balance was $60. $69.33. There is no late fees accumulating. This is not that. This is all stemming
So how is
from
it $9.95
January.
for the 1
Hold
month
on, Ms.
rent?
Bradford. Hold on. Let me listen to what she's got to tell me. So, Ms. Simpson, for December, was there a balance owing in December?
$69.33.
Okay, and
That
was
was
that
it. There's no late fees. That's a partial.
okay?
And
Was
she
that
didn't
just
pay
rent?
anything in January, and this is where it all stems from.
Okay, I'm sorry. So the 69.33, that's rent?
It is billing as rent because we bill to the arrearage.
Yeah, sure. No, I understand that, but I just want to make sure I got
Yes.
what's happening. So 69.33 was the rent for December. That's where she's coming up with 2023 amounts owing, correct?
Yes.
Okay, and then January, the rent itself for January was not paid.
No, it was $12 for renter's insurance. She has a $75 late fee, $625 for rent. So a total of $712 plus the $69.33 leaves her balance for January of $781.33.
And that's not what I received. That's what I'm saying. It's accumulating. So if you're saying that, then it's $637. So you're saying that would make that May month's rent $637 plus the $125 would make it $782. If you're saying that January,
Your Honor,
if you're
she
saying
is
back
so
to
far
March,
off.
you just said that February paid March, May paid April, so it makes May rent late, which would be $647 plus the $130. You just said that. You just said each month goes back a month.
Hold on.
I'm not
So I
arguing with her,
hold on,
Your
I got to hear
Honor.
from both sides.
Right now, she's just ridiculous. She is accumulating late fees every month for the balance that is not paid. She started May's balance was $931.33. She paid $647, which leaves her a balance of the $996.33 plus
How is it
169 court
996 if
fees.
it's 630? I told her I'm at work. I work 10 to 6. I actually work just out some other way. Now I'm at work. The kids are getting upset. That's what they're crying in the background, Your Honor. I work 10 to 6 Monday through Friday. And
The kids are getting upset because you're yelling. You are yelling. You need to calm down. You're not listening. You're not listening to anything that's going on. Stop yelling. And again, Miss Kelly, saying this is ridiculous is just antagonizing her. The judge needs to get a better hold on what's going on. He's allowing it to happen. I love Judge Goggins. He's too nice sometimes, and he's letting a lot of this go. And he should have put a stop to it way long ago. At least that's way long ago. Words, you know how I am with words. All right, let's let this clip play out.
asked her so we can work this thing out. Tell me I have to be to work. I told her that this morning. She said, no, come to work.
Okay, I understand. Mr. Haldy, anything you want to?
Your Honor, it appears to all stem back from a January rent payment that wasn't paid. It hasn't been carried forward. It's been being paid in arrears, and this is what is due and owing. I haven't heard the defendant, other than assuming that it shouldn't be this amount of money. I haven't heard any hard evidence to dispute it.
Okay. I've heard from both sides. I do, to Ms. Bradford's credit, she's acknowledged that January rent was not paid, but she's arguing the late fee somehow or that should not be calculated. Fine judgment for plaintiff at $996.33. Ms. Simpson and court costs, you've got $169.
69.
169 for a total of
$1,165.33.
Okay. All right, judgment for plaintiff showing that that's the amount owed. I allow a writ of eviction after May 31st, 10-day statute.
Thank you, Your Honor.
Thank you.
Okay. All right. Good luck to you, Ms. Bradford. We'll send you a copy of that judgment.
Thank you. Bye-bye.
Bye now.
All right, that one was fun. I'm sorry for the kids crying in the background. I know that was loud. Yeah, all right. Last one. Last one's a short one. This isn't an attitude in court. This is just I don't know how to explain this. Don't know how to explain this last one. I'm not going to pause it during this clip, so I'm going to let this play out. You guys all have a great day. Hopefully you enjoy this premiere, and I will catch you all later. Until next time. Bye.
Name, please.
Trudy Marie Coon.
Ms. Kuhn, this is felony file 242140FY. I'm going to read it to you.
Test Master, on behalf of Ms. Kuhn, for the purpose of arraignment, we have reviewed the charging document and waive a form of reading. We did conduct a screen for indigency and found she does qualify, so she will be having a court-appointed attorney. We request this matter reset for probable cause and preliminary exam.
Okay, so ma'am, you do have the public defender as your attorney in this matter. You wish to argue for bond?
Yes, Ms. Kuhn was previously bonded on the same charge. It looks like they amended the complaint and then reissued these charges. Before the original one, I did represent her. She had no issues attending court. She takes care of herself and her mother, who is in the hospital right now, which has been, throughout this court case in the past, one of her other priorities on top of, and with that, she still was able to attend all of her court dates. So we ask that be taken in consideration and a PR bond be granted again. Thank you.
Okay, but ma'am, you're already now bond, out on bond for a felony meth that occurred in February, right? So you caught
Yes,
this
sir,
while
but-
you were on bond on already?
Yes, sir.
All right.
But
So it's gonna be, ma'am, your bond's gonna be $2,000 cash or surety, no drugs, no alcohol, no marijuana.
I know that. Please, Honor, I don't have no money.
Ma'am,
Nobody has any money.
you picked up a new felony while you're out
I
on
know,
bond
I
for a
know.
pending felony.
I know, but my
and
mom's
there's
in the
different
hospital.
kinds of felonies, so we're all set. You already have
Please,
court
Honor,
dates.
you please, I beg you.
You
I
have
beg
a
you, Honor,
probable
please.
cause
Can I
conference
get a-
on May
can I-
30th. You have a preliminary
Can I
hearing on
please get a
June
PR
5th.
bond?
That's in courtroom A in front of Judge
PR,
Scott.
please.
Man, you shouldn't even have gotten a PR bond on your first.
I didn't mean to. I thought it was taken care of because on Monday I thought it was taken care of. I didn't know. I didn't know. Please, Your Honor, I did not know.
Are you on probation from your felony in 2021?
No, I'm not on probation yet. No, I'm not on probation. I ain't even finished with that court yet. I don't go to the court for that until July 3rd. Please, I beg you, Your Honor. I need to get out so I can get the house straightened up before my mom comes home.
We're done.
Please.
All right, I know I said I wasn't going to pause it, but I just want you guys to all pay attention to two different things. First off, I love this judge, but he called her Beth, you know, probation for meth, and he just said Beth. That was awesome. And also, she needs to get home so she can clean the house before her mom gets home. How old is she? That's a wild statement to make in court. All right, now I'm out. Have a great day, guys.
Nobody has, Your Honor. Please, Terry, please, beg you.
Ma'am,
You
your
don't
bond
need, nobody
should
has
be
the money
higher
to
than I
help
just
me.
said it. If you keep talking, I'm gonna set your bond higher. 2,000 cash surety when you're already out on a felony bond where we gave you a chance to behave and you picked up a new felony. That
But
is
I
no
didn't
way
know it was
in
a
shape or
felony.
form
I
a
didn't
PR
know.
bond. You're all
I
set.
didn't know it was a felony.
Okay, please come over here so the next person can vote.
You know it's a felony. I pretend it's a felony.